Welcome to our third presentation covering Chapter 10 of our textbook, which covers remedies in contract law. As you know, we have been talking about remedies, which is just another word for damages, and we have talked about those remedies in two categories. The first category being legal remedies, the second category being equitable remedies. In our first lecture, we talked about legal remedies. In our second lecture, we talked about equitable remedies. And in this lecture, we're going to kind of go through some practical scenarios with respect to legal remedies and talk about how those would actually play out, how you actually make those calculations. This can be a little tricky. So if you find yourself thrown for a loop on this, I like to tell folks that this is not a huge part of the testing that you'll get in this class. So I don't want you to get bogged down too much in the weeds in this. Obviously, if you've mastered everything else and this is the part that you're struggling with, then yes, do get in the weeds in this. But if you're finding that this is throwing you for a loop and there are other things out there that are also things you're not quite confident on, I recommend that you focus on those materials first, get a good grasp on that, and save this as that kind of final thing that you're going to do, because again, this can be tricky. It can be a little bit hard to get your thought process around sometimes. And while it's certainly something that we'll test over, it's not something that I do a deep dive on testing on. But anyway, let me cover some examples, because the thing about calculating legal remedies is it's math. It's looking at problems from a mathematical standpoint. And so, the way to do math is to, do math. So let's get started. Let's talk through some scenarios. You'll find these scenarios actually posted in a Word document in Chapter 10. So the same material is available to you. Let's read through these kind of word problems to see how they play out. So we're going to look at a scenario with compensatory damages first. That's the only kind of damages that we have in this case. So we have Bob. Bob signs a contract agreeing to buy 10 hours of landscaping services from Green's Landscaping. And the hourly rate that Bob has agreed to pay is $50 an hour. So that's the contract. If Bob breaks the contract and does not use any of Green's landscaping services, what would the compensatory damages be? Well, we already see the numbers here. We see $10 and $50. That is what he would owe Green's Landscaping Services. That's the loss that Green's Landscaping Services is experiencing. Now you can look at this in a couple ways. You could say, well, probably Green's Landscaping employees are paid on an hourly basis. And so Green was able to excuse those workers from work during that time, and so he was able to save some of his labor costs. But let's assume, for the sake of argument, that his workers are all salaried. Doesn't seem very logical, but let's just assume that that's the case. And so he actually doesn't receive any kind of reduction in his expenses when Bob doesn't actually use the services. That's what our assumption is, but it's maybe a little bit of a question mark there that's actually how that would play out. But for the purposes of this assignment, we'll assume that Green's landscaping employees are paid on an hourly or salaried basis, and therefore Bob would clearly owe 10 times $50 in compensatory damages. Okay, but let's imagine the other scenario. Let's imagine that Green's Landscaping is the one who breaches. So Green's Landscaping breaks the contract. As a result, Bob has to hire another service. Must hire another service. And of course, he's doing this last minute, so he's not able to get the good rate of $50 an hour. He now has to pay $60 an hour. He still needs the 10 hours. So he is going to pay this other service $600 instead of the $500 that he was expecting that he would need to pay. So under this scenario, Bob would be entitled to $100, which would be 600 minus 500 equals 100. And that's all about compensatory damages. So you can see it's just a matter of crunching the numbers to come up with that amount. If you know what kind of damages they are, it's a little bit easier to figure out. But in the real world, you don't. You don't know if it's what category it is until you read the scenario and think through it. So now let's look at a scenario in which we have both compensatory and consequential damages. Okay, so we have Bob and Larry. They enter into a contract. Bob owns a vase. It's a very expensive vase. It's worth $5,000, or at least that's what he and Larry negotiate over. But Larry is going to pay Bob $5,000, and Bob is going, and then Larry will own the vase. Well, actually, Larry is an antique vase dealer, and so he has entered into a contract with another buyer for $5,500, right? That's the price here. Let's just do a little parenthetical here. Oops. 5,000 times 1.1 equals, so that's the price. So basically Larry is flipping the antique vase. Hopefully not literally, because that could cause it to break, but let's just metaphorically, that's what he's doing. He's going to pay Bob $5,000. He's going to be able to turn it around and sell the vase for $5,500 to somebody else. So Larry makes a very quick $500 profit. Okay, but you know what? Bob finds out. He finds out what Larry's doing, and he says, why don't we cut out the middleman? Why don't we cut out Larry? I'll go directly to this collector and sell the vase to the collector. At the time of this sale, I'm sorry, it's not a doll anymore, it's a vase. I switched the scenario, didn't I? At the time of the sale, the vase's value has gone up to $6,000. It doesn't really matter whether the collector that Bob sells it to, let's just give him a name. We'll name her Mary. It doesn't really matter whether Bob sells it to Mary for the $5,500 or the $6,000. It could be either one or some other amount. That's not really important to the story. So now Larry sues Bob for breaching the contract. There's two ways of calculating the amount. One is to look at compensatory damages. And that is, well, on the date of the breach, let me just switch this, make this a little precise, more precise. On the date of the breach, the value on the vase's value on the day of the breach is $6,000. So presumably that means that on the date of the breach, Larry could have gone out and bought basically an equivalent antique vase to the one that he had contracted to buy for $6,000. But actually Larry had a contract to buy it for $5,000. So his damages, his compensatory damages are $1,000. He should be able to sue Bob for $1,000. That's one way of approaching this equation. But another way would be to look at Larry's consequential damages. Okay, so in this scenario, Larry wasn't buying this to keep the vase. He was going to flip it to Mary, right? And so he was planning on making $500 in profit. That's what Larry lost out on because Bob breached. He lost out on that 10% profit, that $500. Now, of course, when Larry and Bob were initially negotiating, Bob didn't know anything about this second deal that Larry was entering into, or maybe he didn't. We'll assume he didn't. So there might be an argument that consequential damages aren't appropriate in this case because they might not be foreseeable. But let's assume for a second that Bob knew Larry was a dealer in antique vases, that he himself is not a collector. And so the idea that Larry might be flipping the vase to somebody else was not completely unexpected. So it might have been foreseeable, and so therefore consequential damages might be available. Now in this situation, Larry would not be entitled to both compensatory and consequential damages because this would result in a collecting over 100%. So Larry is going to have to engage in an election of remedies. He can pick to collect the compensatory damages or the consequential damages. There's really no need to capitalize those words. Which one is Larry going to want? Well, I'm predicting that Larry is going to want the compensatory damages because that's more money, right? The figure is larger. If we were to allow Larry to collect both, then you get $1,500. But there isn't $1,500 in this scenario. I mean, there's no way that Larry would have actually gotten $1,500. He might have gotten $500 if Bob hadn't breached. He might have even gotten $1,000 if he hadn't had that contract with Mary, because then he could have flipped the vase for $6,000 to another person, Teresa, we'll say. But in this scenario, there would have been no way that he could have sold it to Mary and then sold it to Teresa. There's only one vase that Bob is contracting to sell. So Larry has to pick one of these doors. He can pick door A, which is compensatory damages, or door B, which is consequential damages. So those are the two sums, and obviously Larry's going to choose compensatory damages. Let's look at another scenario. We're going to look at consequential damages. So this is just a scenario of consequential damages. This is actually a very famous case. This is Hadley versus Baxendale. If you elect at some point in your life to go to law school, you'll almost certainly read this case. It is a case of the common law. It's actually from Great Britain in the 19th century. You may wonder, well, why do we have a case in our common law from the 1800s? I mean, we were our own country back then. We weren't a colony of Great Britain, so why do we have their law? Well, that's one of the aspects of the common law, that cases that are from other jurisdictions that are especially interesting or significant oftentimes are given a fair amount of significance and weight. It's not a mandatory authority, but it's a persuasive authority situation. Anyway, Hadley versus Baxendale is one of those cases. And so you will see it being a case that is discussed even in the United States. So let's talk about consequential damages. In this case, a miller, somebody who grinds wheat or corn or whatever, I'm not quite sure what the mill actually was in the business of grinding. Anyway, he wanted to purchase a crankshaft for a steam engine for his mill. Nothing unusual about that, apparently. In order to have a mill at this time, they were typically, I guess, operated by steam engines. Well, you have to have a crankshaft. Your mill isn't going to work without one, so it's an essential thing. So anyway, he hires a business to make this crankshaft for him. And the business, of course, agrees. They enter into a contract, and there's a particular date that the crankshaft is supposed to be delivered to the miller. I don't know if Hadley's the miller or Baxendale's the miller, so we'll just use miller and crankshaft manufacturer as our names here. Unfortunately for the crankshaft manufacturer and for the miller, I guess, the crankshaft was not delivered on time, so the crankshaft manufacturer is in breach of the contract. Everybody agrees with that. As a result of the crankshaft not being delivered in time, the miller isn't able, this is the time of the year where farmers are harvesting their crops, and so they're taking their crops to, or they want to take their crops to the miller so that it will be milled. And when the miller doesn't have his crankshaft and therefore can't mill the produce, then those farmers take their crops to another miller. Excuse me. And as a result, the miller loses out on all this business. Well, the miller wants to sue the crankshaft manufacturer for all this lost business. And the crankshaft manufacturer says, well, we didn't know about this. We didn't know you didn't have a backup crankshaft. We didn't know you had to have this in order to function. And so the crankshaft manufacturer is saying, we didn't know, we didn't have a basis to know what your peril was. And so for that reason, the court said that the crankshaft manufacturer is not responsible for the loss of business that the miller experienced. But if the facts were different, let's say the miller had told the crankshaft manufacturer, I need the crankshaft back in my mill by X date, or when the crops come in, and they're expected to come in about then, I'll lose all this business, and I expect that amount of business to be whatever that size is. Well, if the miller had alerted the crankshaft manufacturer to that, then consequential damages would have been foreseeable and not speculative, and the court might have ruled the other way. So you can see there's something indirect about that you need to have more information in order to calculate what the consequential damages would be. You have to know the particular business circumstances of the miller. If the miller had had a second crankshaft that he was able to use, then he wouldn't have experienced those consequential damages. And the crankshaft manufacturer wasn't in a position to know whether or not the miller had a backup crankshaft. Here's another example of consequential damages. A retail store buys customized software to run its cash registers and its inventory system. One day the system breaks down, it crashes, and the store has to close because they can't run their cash registers. So they can't accept money, they can't pay out change, so they just have to close. So as a result, they lose all the sales that they would have otherwise had on that day. And we'll assume that the store has some kind of record of how much they had sold on that particular day, say the year before. So they have some comparables to make between year to year in that sense. Well, it's probably pretty foreseeable that a business would have to close when its cash register software crashes. And so the cash register software company should have been able to anticipate that it might be on the hook for the lost profits from that day of sales. So that would be a pretty foreseeable damage. That would be an example of a consequential damage. We already covered this scenario in the PowerPoint that we covered for Lecture 1. And again, we talked about widgets and the price of widgets and widgets being delivered too late and all that good stuff. So let's move on to another scenario. But this is our last scenario that we'll cover. Okay, so in this scenario, a man, we'll call him Bob, builds a restaurant. He hires a general contractor to design and create, the blueprint and to actually build the restaurant. Unfortunately for Bob, the general contractor didn't do the best job, and in fact, there is a defect in the restaurant design relating to the roof. There's actually a problem so that if there is a hard wind that blows the restaurant at just the right spot, the roof will just pop off and blow away, and so that's not a good thing. This particular area where the restaurant is a bit of a wind tunnel, and so it's very anticipatable that this event will happen eventually, and that at some point in the not too distant future, probably the roof will be blown off. Don't know when, and obviously the manufacturer didn't anticipate this, didn't want this to happen, and certainly Bob didn't want this to happen, but it might happen. Anyway, things are going along fine. A year or two has passed. So far, so good. There's not been any problems with the roof. Bob has no reason, Bob the restaurateur has no reason to think there's any problems with the roof. Anyway, he decides he's had enough of the restaurant business and he decides to sell it. He's going to sell it to Larry. And Larry and he actually arrive at a purchase price, but there's a few details to work out before the closing. And so they enter into a contract on Monday, but they're not actually going to close until the following Monday. Well, in the intervening week before the close, there's a bad storm, and the wind whips through that wind tunnel and lifts the roof up off the restaurant, blows the roof away. The rain keeps on coming. So inside the restaurant, everything is waterlogged and soaked, and the wind whips everything around. So all of the furniture and the supplies and the various cash registers and kitchen stuff is all destroyed and mixed up and just in terrible disarray. And so the buyer, Larry, comes and sees the restaurant in this disaster condition and says, wait a second, I don't think I want to buy this place after all. This is too risky. There seems to be some design problems with this building. I'm backing out. And in fact, the contract that Larry had entered into with Bob allowed Larry to back out of the transaction. Now, Larry is going to back out, and he has the contractual right to do so. Well, Bob has somebody come out to evaluate what went wrong with this building, and the expert opinion is that identifies the roof problem, and so Bob wants to sue the contractor who built the restaurant. And so the issue is, well, what kind of damages can Bob collect in this situation? So let's do an evaluation of this. Let's consider, first of all, compensatory damages. Okay, well, given the fact that the roof failed and there wasn't anything that Bob or Larry had done to contribute to the roof failing, and this wasn't, say, a hurricane that came through, but just a strong wind, as is likely to happen in this particular part of the country, it seems pretty clear that whatever expense needs to be borne to fix the roof and to restore the roof is clearly a compensatory damage and is the responsibility of the contractor. So reconnecting the roof to the building, or perhaps completely building a new roof, whatever needs to be done, clearly would qualify as compensatory damages. Then let's consider incidental damages. Well, also, by the way, in addition to redoing the roof, we'd also have all the damage to the inside. The cash register was destroyed. Pots and pans flew out of the restaurant and were destroyed. The plates in the cupboard were destroyed. The chairs and things like that. The windows blew out. All those things would need to be replaced. Those would be compensatory damages. But let's go and talk about incidental damages. Well, Bob wants to save as much of the stuff as he can, and so he's going to go out and buy some tarps to cover what is salvageable. He may also want to rent a storage space to put the chairs and the cutlery and the cash register and what can be salvaged into a dry, safe location that isn't in the elements. Those types of expenses would be incidental expenses that Bob would be entitled to compensation from the general contractor. Now, consequential damages, though, are another situation. Consequential damages would be the loss that Bob experienced because Larry backed out of the sale. Now, if the general contractor had known that Bob was planning on, at the time that the general contractor entered into the contract with Bob, if he had known that Bob was planning on flipping his restaurant building, say 12 or 18 to 24 months after he built it, then maybe it would have been foreseeable that he would have been in the business of selling the land, the building, and so it would have been foreseeable. But this seems a little bit unlikely. Most people don't enter into a business and then plan on selling it just a few months later. And so under those circumstances, I think the lost profit that Bob experienced because he lost the sale to Larry probably would not be recoverable as a consequential damage. So we have incidental damages, we have compensatory damages, but in this case, I think it would be difficult for Bob to prove consequential damages. We've already talked about this, but again, restitution focuses upon the defendant and reliance focuses upon the plaintiff. I try to come up with mnemonics for these, they're a little bit hard. One mnemonic that you might want to think about is reliance has an L and so does plaintiff, but defendant doesn't have an L, and neither does restitution. So if you're trying to keep reliance straight from restitution, remember the L in reliance and the L in plaintiff. Another way to think about it is who is relying? When we say reliance damages, who is relying? Well, it's the plaintiff who's relying, right? And so that can be another way of remembering reliance relates to the plaintiff. Restitution relates to the defendant. I hope that this information has been helpful for you, kind of connecting the dots, seeing a little bit of the practical application of the ideas of incidental, consequential, and compensatory damages to some real, real life scenarios. Thank you for your attention. Again, as always, if you have questions, please send me an email, come to my office hours, or raise those questions in class. Thanks for your attention and have a great day.